guy made a comment on TikTok, on my TikTok account there last week, about how difficult it was for employers to employ people nowadays, that the dice were completely loaded against the small business person who wanted to take on people, and the laws were going to do them down, that it was a futile exercise, that they were leaving themselves open for all sorts of claims, very, very costly claims, and it was a complete change from a number of years ago. And I disagreed, to put it mildly, and I did a response video. But my disagreement was on the basis that an employer does have the opportunity to take on an employee on probation, or give him or her a probation period in the contract of employment. Now, that probation period could last 6 months, but it could also be extendable up to just short of 12 months. And I made the point as well then that if you cannot figure out if somebody is right for you within 6 months or 12 months, then perhaps you should consider your position as an employer or a judge of people, or perhaps you should delegate the task to somebody else. Because most employers, most small business people, can figure out whether an employee is right for them or not within 6 weeks, never mind 6 months or 12 months. But in any case, I went on to make the point that if you take on somebody and you give them a contract of employment and they're on probation, then by law you can get rid of them for good reason, bad reason or no reason. And another fella then jumped in and he was saying, oh no, you have to give them 3 reviews and you have to go through a procedure and so on. That is absolute nonsense. If an employee is on probation, the whole idea of the probation period is to see if the person is right for you as an employer or not. If they're not, you can simply terminate their employment in accordance with the contract. And the contract should say, during the probation period, your notice period will be 1 week. So you can terminate the employment on the basis that they have failed to pass the probation period, or the person simply isn't right for them, or isn't a good fit, or it's not working out, or whatever. You don't have to go through the disciplinary procedure. You don't have to go through any procedure. That's provided one thing, and that you don't terminate them and give them a reason that it's because of some conduct, some inappropriate conduct. If that's the case, that's a different situation. But in the normal run of affairs, you can terminate the employee's employment if they're on probation for good reason, for bad reason, or for no reason. And sometimes the smartest thing to do, quite frankly, from an employer's perspective, is not to give any reason and just say, look, you're not right for us, or it's not working out, or whatever. Now, that's the probation period. People then were on about, oh, what happens if somebody passes probation after month 6, then you're stuck with them, etc. You're not. You're not. And the reason for that is because in order to bring a claim for unfair dismissal, an employee must have 12 months continuous service. Unfair dismissal requires 12 months service. And if an employee doesn't have that, they simply cannot bring a claim for unfair dismissal. Now, they can bring a claim for discrimination, or they can bring a claim for being penalised for having made a protected disclosure, but they can't bring a claim for unfair dismissal unless they've 12 months service. And as I was having this debate online with these guys on TikTok, I read an article there in the newspaper about a WRC case where a butcher was fired from his job. He was terminated 2 days short of the 12-month period. So 2 days short of the 12 months that he needed for unfair dismissal, his employment was terminated. And the company basically said something similar to, you're not right for us, or it's not working out. They told him that there was a misalignment. There was a misalignment between him and the company. And the reason for that was because of some emails that he had sent to management, which the company viewed as inappropriate. And the adjudicator in the WRC hearing obviously viewed them as inappropriate as well. Because, firstly, before we get to the adjudicator's determination of the issue, the employee was a butcher, and he was working for a company. He raised a number of issues, and he didn't get a response within a satisfactory period of time as he saw it, and he sent some follow-up emails which, to put it mildly, were inappropriate, especially in the context of starting a new job, and especially when you don't have the protection of the unfair dismissals legislation and you don't have 12 months service under your belt. And just to be clear about that. Now, I was saying to you that in order to bring a claim for unfair dismissal, you need 12 months service. This fella was terminated 2 days short of the 12 months service. However, he had made reference in some of his emails to SIP2. And so, if a person is terminated without 12 months service, but they're terminated because of trade union membership, well then the 12 months service is not required. And so this chap claimed that he was terminated because of the mention of or his involvement with SIP2. And so he said that the 12 months was disapplied. The 12 months service was disapplied. 12 months service from his perspective was disapplied, and he could bring his claim. So this chap was claiming that he was fired for trade union membership. In the case itself, the tribunal, the WRC, rejected the butcher's claim that he was sacked for being a member of SIP2. And the adjudicator concluded that his emails accusing its managers of dishonesty and unethical behaviour were the main reason he lost his job. And they were the main reason why the employer felt that he wasn't the right good fit for them, or that was misalignment. And you can draw your own conclusion as to whether that was a predictable sort of an outcome. The complaint under the Unfair Dismissals Act 1977, it was against Tipperary Sustainable Food Company, trading as James Whelan Butchers. The worker, Daniel Holland, he wrote that he had been told the reason for his dismissal was, quote, misalignment. And that misalignment, I would suggest, is a word that was probably advised to the employer from their legal advisors. Similar to, you're not a right fit, or you're not right for us, or whatever, but fairly bland. No element of accusations of conduct or anything of that nature, and there's a reason for that, but we'll talk about that some other time. He added that he asked what the firm meant by misalignment, but was, quote, refused a response, and he formed the belief that he lost his job because he'd referred to SIP2 in an email to Human Resources, and SIP2 then represented him. They argued that the dismissal was as a result of its client's trade union membership, which disapplied the usual minimum service requirement of 12 months under the Unfair Dismissals Act 1977. He had joined the company, Mr. Holland, on April the 24th, 2023, and his employment was terminated on April the 23rd, 2024. This left him 2 days short of the 12-month service. Denying the complaint on behalf of the company, the barrister for the company called the worker's accusation about trade union membership a retrofit because Mr. Holland didn't have the service. Bottom line is, counsel for the employer knew he didn't have the 12-month service, and he was accusing the employee of basically trying to fit the facts or get the facts to fit, i.e. trade union membership, no 12 months required, and that didn't wash, quite frankly. In his evidence, Mr. Holland said that the first 6 months in the job were all okay and that he passed his probation after that with flying colours. And this is the question of, he's passed his probation, big deal, doesn't have a 12-month service, can't bring a claim for unfair dismissal. That's the reality of it. So you're in a sort of a Bermuda Triangle, a sort of a grey area after you pass probation. So between month 6 and month 12, month 7, 8, 9, 10, 11, you can still be fired, quite frankly, and you cannot avail of the Unfair Dismissals Act because you don't have 12-month service. So he said that he passed probation with flying colours. The WRC heard that in email correspondence with the company's head of human resources, Siobhan Keane. Mr. Holland said that he was told that Darren Walsh, the firm's head of operations, would contact him about a particular matter. But Mr. Holland wasn't happy. He replied that he'd posed relatively simple questions to Miss Keane and was concerned at her lack of response. He went on to write, "The fact that I have reached out to you for clarity and the only offering as any form of answer is that Darren will be in contact to discuss." He wasn't impressed with this. "I find it truly unethical that this very simple request to yourself through the correct channels has now become a back alley sideways conversation with someone outside of the People and Culture Department," he added. So now he's accusing management of being unethical, or the company of being unethical. That's not a way to win friends and influence people, quite frankly, especially when you don't have the protection of 12-month service under your belt and don't have the protection of the Unfair Dismissals Act. Owen Keeney, BL, Bachelor of Law, barrister, appearing for the company asked Mr. Holland if he saw the email as respectful and appropriate way to deal with a colleague. Mr. Holland's reply was that he did not see it as outside the bounds or unacceptable. That was a big mistake. When Mr. Holland was referred to another email in which he stated that the two managers had, quote, not demonstrated honesty in their interactions with him, he stated that it was still his position. So here he is accusing managers of not being honest with him. Mr. Keeney said that it was an extraordinary thing to say. Mr. Keeney is the barrister, and he said it was a stop the lights moment in an employment relationship. And I think if you're watching this video and if you're an employer and you have an employee sending you emails of that nature and calling into question your ethics and your honesty, I think you may agree with that counsel that it would be a stop the lights moment in an employment relationship. The company's general manager then said she had concerns about the manner in which her colleague was being called into question. The witness said that she and her Mr. Walsh formed a view that the employment relationship was over and that they could not see an alignment between the tone and content of those emails and the culture of their business. And that's where the misalignment came from. The fact that Mr. Holland had mentioned his trade union membership did not enter their thinking, she added. In her decision, the adjudicator wrote that the wording of Mr. Holland's emails to Miss Keane, a senior manager with the firm, were, quote, likely to have been considered by the respondent to have impugned the employment relationship and left it, quote, damaged beyond repair. I conclude that the complainant's trade union membership or activities was not the most important factor in the parting of the ways between the parties, she wrote. She found that the dismissal was not wholly or mainly related to Mr. Holland's trade union involvement and dismissed the claim. So that is that chap who, Mr. Holland, butcher, didn't have 12 months service, and that reporting is from the Irish Times. He didn't have 12 months service, and if he didn't have 12 months service, he cannot bring a claim for unfair dismissal. He was seeking to, as the barrister said, retrofit his claim and claim that he was dismissed because of the mention of SIP2 and SIP2 membership. But that didn't wash. The facts didn't support that. The evidence didn't support that. This is another case where 12 months service is absolutely key. If you're an employer, if you're an employee, 12 months is very, very important, because without 12 months service, Unfair Dismissals Act is not open to you. What is open to you is discrimination claim or a protected disclosures claim, but you need evidence for those claims as well. So the bottom line is, if we circle back to the beginning of this video where the small business owner on TikTok, on my TikTok page, was saying that, it's impossible for employers. Here's an example of a case where it's not impossible. This employer terminated this chap because they found that he wasn't a good fit for the company. They found that there was a misalignment, and they terminated him 2 days short of 12 months, and they have been able to withstand and stand up. Now, the cost, they have experienced and incurred the cost of defending the claim, but they've won the case. So this idea of employers are completely hamstrung in dealing with employees, or the law is completely stacked in favour of employees, or it's an appalling situation, it's a Dante's Inferno sort of a situation for employers nowadays taking on employees. It's a shock and risk and they'll have you on the road. That's not true. That's not true. And I'll say now what I said on TikTok. If you give an employee a contract of employment and you make provision for a probation period of 6 months, 7 months, 12 months, 12 is the max. If you do that, then you can terminate the employment for good reason, bad reason or no reason during probation. And I say again that if you as an employer cannot figure out whether an employee is right for you or not within 6 months or 12 months, then you really should consider outsourcing the job of taking people on, because most employers with a bit of street savvy are able to figure out whether an employee is right for their organisation or not within 6 weeks, never mind 6 months. Anyway, that's my experience, that's my view, it's just an opinion. Hit the thumbs up button if you find the video useful, and you may be interested in subscribing to my YouTube channel. Thank you very much.